Alex here with a legal nuts and bolts video on abusive process. This is something that I've gotten a few questions on and I wasn't going to cover, but then I remembered my ex's attorney did try to bring abusive process up against me one time. So I did look at it a little bit in the past, and the reason I don't really think abusive process makes a whole lot of sense will become clear towards the end of the video. But it is actually a type of claim you can bring against an opponent, and as much as I don't think there's a point to it, based on my personal experience, somebody else might find some use in actually researching it and trying to use it. Abusive process is basically a claim that you bring to the court against an opponent that you basically are alleging put you through the legal system in an effort to coerce you or force you into doing something that was unrelated to whatever they put you through. So let me give an example. I'm going to use a really common example that comes up. Somebody filing a, we'll say child custody action, and then their opponent filing a restraining order, which is actually not called that in Nevada. It's a petition for order of protection against domestic violence. Most people don't understand what that is. Most people know it as a restraining order. The opponent files that, and then while that proceeding is pending, they send in, let's just say they send an email to the person who originally filed the child custody complaint or petition, and they tell them, if you let me have custody of the children, I will abandon this restraining order I'm trying to get against you. That is kind of one of the best examples that I can give, where you can show that they never actually were victims of domestic violence. They were never actually afraid. They never actually needed protection, or like a restraining order or an order of protection against you. They just filed that to get something they wanted that was completely unrelated to that whole entire action. That sounds like such an obvious thing that happens all the time, but the problem is proving it. My understanding is that few people can really prove that somebody filed a specific action just to twist their arm or coerce them or trick them into doing something else that they wanted, that was completely unrelated to whatever it was they filed. Another example might be somebody has a, let's say, a probate action in court, and there's a dispute over the will. And let's say that one of the heirs sues the other heir over, I don't know, something that happened in the past that they weren't going to sue over, but they file the suit now, and then they tell them, if you go to that probate hearing tomorrow and you testify this, this, and this, I'm going to go ahead and just drop this case and just let you off on that. That's another good example of abusive process. They're not filing actions because they actually want the relief they're requesting in the action. They're filing the action to get something else completely unrelated out of the person. It's a control mechanism. It's a manipulation tactic. It's coercion. It's wrong, but my understanding is that it's incredibly hard to prove, because the defense anyone can make is, I actually did feel like I was a victim of domestic violence. I actually do need that protective order. The other defense for the other one is, I actually did need to sue for that time they wrecked my car. I wanted the money back. I mean, I don't know. I suppose it may be possible for a person to actually win one of these cases if they can really show that the other person lied. I know it's necessary to actually win in the action that you're claiming was an abuse of the process. If you don't win in that action, so let's say that the protection order is filed and you lose and the protection order is entered against you, my understanding is that the case law for abusive process won't even allow you to even try to win on abusive process, because the other person actually prevailed. So one of the first things you have to do is actually win that other case. And I imagine that it takes a little bit more than that, because you're going to have to file a whole separate lawsuit demanding monetary compensation under abusive process. And in that lawsuit, not only are you going to have to show that you won the ridiculous one that they filed, but you're going to also have to show somehow, some way, that there was no point to that lawsuit in the first place. I'm not sure that abusive process, even in that circumstance, makes a lot of sense because in Nevada, at least, we already have statutes that allow you to recover your attorney fees and costs if you can show that your opponent took some position or filed something with no reasonable legal basis or to just harass you. So there's already a remedy available in the actual action that's been filed, which is one of the reasons why I really didn't even want to do this video. So just going back to the old examples, if somebody files a petition for an order of protection against domestic violence and you win and the petition's denied, you could, in that same action, after you win, file a post-judgment motion for attorney fees and argue that your opponent lied and they brought the whole thing to just harass you and annoy you, or that they brought it without any reasonable basis. And you can get your attorney fees that way anyway. So it's like, why file a whole separate case if there's already a thing you can do to get your money back? I guess this is really where I get hung up on the whole abusive process thing. There may be something out there that I missed, but I looked into it, and the way I defended myself against my ex's attorney was she tried to use it in opposition to one of my motions, and I defended on reply saying, if you think I'm abusing the process, you need to bring a whole separate lawsuit against me. This is a claim for money damages. This isn't something that you can use to block a motion. And the judge ignored it. The judge didn't even mention anything about the my ex's attorney's abusive process argument in his order at all. It was just like he probably just smirked and just rolled right over that. That being said, there is going to be one more thing I'm going to mention before I end this video. I do understand that in criminal cases, an abusive process claim might make more sense because I don't think, in fact, I'm pretty sure that you can't file a post-judgment motion for attorney fees in a criminal case and claim that the prosecutor filed the action to just harass or annoy you. You can do that, but it's done in a completely different way. I think they call it malicious prosecution, and I think that's a subset of abusive process, or it's connected to it in some way, or it may be the same thing. I'm not going to do the research on this because, as I mentioned with these videos, it's really me here trying to help you help yourselves. It's me here trying to let you know that these things exist and to look into them and to do your own research. But I do understand that in criminal cases this makes a lot more sense. People do bring lawsuits for malicious prosecution, vindictive prosecution, prosecutorial misconduct, and things like that that stem from criminal cases. That actually does make a lot of sense to me because there's no other way to really recover those attorney fees. Otherwise, you would have to bring a separate case for money damages against the prosecutor. Or the city attorney or the district attorney's office or whatever. I think with that, I'm going to go ahead and end this video. If anyone here wants to mention anything down in the comments below, feel free to do that. You're going to see a whole bunch of cards popping up all over this video. Definitely check some of those out because I'm referencing other videos, and it'll probably answer a lot of your questions. But anyway, with that, I'm going to go ahead and end this video, and I hope this was informative to people. I will see you guys next time.